Welcome to the EOcafe, where the EO community meet. This is our first EOcafe after the summer break, and I hope you all had a very good one and are refreshed and working up to the end of the year. Just to start with a reminder of the rules for the EOcafe. Please keep your microphones off unless I ask you to come in and pose a question directly, but you're very welcome to keep your camera on so that we can see you. It's nice to see who's with us and to see everyone that way. And if you have a question that you want to put to Susanna, then you can pop it into the chat and we can then see it. And if we take the question, that's when I'll ask you to turn your microphone on. So rather than me reading out your question, you pose it yourself. As we maybe have some newcomers joining us today, a reminder that the EOcafe is an informal exchange between myself and our guest, who today is Susanna Matsanova from the European Commission. Our meeting is virtual with the specific goal to enable the EO services community to network, to meet. We started it right back in the time of COVID, and whilst at the same time being informed of some topic which is of interest and sensitive to the community. The topic may be technical, it may be legal, it may be market or business related. We try to vary the topics and to keep the interest in different directions and interest different people. We do have a lot of new companies entering the area, so we also try to give them an opportunity to understand a little bit the institutional setup, because not all people understand the relationships between, well, ESA, the European Commission, USPA, and many of the other actors. So this is an important part of the market development. I'm pleased we had over 300 people registered for today, which I think is the second highest ever. Somebody can correct me if I'm wrong. For the first part of the EOcafe, I'll have an exchange, a conversation with Susanna. And later on, invite you to ask questions, which, as I said just now, please write down into the chat, and then we'll ask you to take the floor. So today we're going to talk about the European Commission proposal for a European Space Act. And to start with, perhaps I can just invite Susanna to say a few words to introduce herself, her background, and how she has become head of unit for the space single market in DG DEFIS, who of course we all know very well. Susanna, welcome.
Yes, thank you very much, Jeff. Thank you very much, and good afternoon to everyone. I am really pleased that I could join this EOcafe today. This is the first time that I have this occasion to do so. It's a community of specialists, so I'm very happy that I can bring you today some good news about the EU Space Act, what we are proposing. A little bit first starting with myself. So as said, I am the new head of unit of a unit called Space Single Market. I have started this position just a couple of months ago, but I have been around in the space business in the European Commission for the last, let's say, 15 years ago in different positions, dealing with Galileo, secure connectivity, market uptake. So this is a new challenge for me as well, and I'll be happy in my best of my capacity to deliver as much as I can the explanations on what we are proposing and how do we see this.
We're a very friendly community, and look forward to working with you. We'll talk more about that. So the Space Act proposal has been launched by the European Commission on, I think it was June the 25th, and is currently being reviewed and negotiated by the European Parliament and Council. And as it's being negotiated, there are some topics which are a little bit sensitive, and so there may be some questions that you ask, or even I ask, that Susanna will not be able to answer today for the sensitivity. So please bear with us for that, and recognise that this is a little bit sensitive at the time. Some of the provisions of the proposal have already raised questions from the EO private sector, both from data providers and service providers' perspectives. And already we start to have some terms that we need to perhaps understand a bit better. ERSC has a working group, so anyone in ERSC who's interested is willing, able very welcome to participate to the working group that Michel Hermes organises and runs. And this working group will produce a position paper which will express the industry views in due course. And maybe later on this afternoon, Michel will say a few words about that. So without any further ado, let's jump straight into this topic. And so, Susanna, maybe you could give us an overview of the proposed Space Act and what are its goals.
Yes, so as you said correctly, the Space Act has been tabled by the European Commission on the 25th of June. It is a legislative proposal that is quite big. It has 119 articles. In general, we can divide it into, like, say, three main categories. There are articles and parts of the act that deal with of course, the subject matter and the scope and the governance of how we need to get organized in order to make this happen. And then there is a substantial part on the technical requirements. So this is the second pillar. And the third part, there are a number of support measures that we have in order to facilitate for the companies the compliance with the provisions of the Act. So this is, in a big words, what it is. But maybe before we dive into that, yeah, thanks for the chat. Yeah, before we dive into that, it would be nice to maybe say why are we doing what we are doing, and that's very important. So let me just recall that clearly US space operators and data providers, you probably know this very well, that currently the orbits are getting more and more congested. Since the rise of the space age, we had more than 20,000 satellites launched. Out of these, I think today there are around 8,500 that are operational, and this number is exponentially growing. So what does it mean? It means that there is a risk for collisions. There is a risk of launching satellites that we would not be able to manipulate and have a safe entry of these satellites into the atmosphere. So there are a number of risks related to the congestion of the space that we see. And this is one of the key reasons why we are proposing this act. The second one is related to the fact that the space is not only congested, but is also contested. By this we mean that there are different actors that are trying to get, let's say, there are different threats in space to our space infrastructures, and that these are potential risks. If, for example, there's a cyber attack, it's a risk for not only for the satellite that provides those services, but it could be a risk to other satellites in case this satellite is taken over by somebody who can operate it. So these are the two main preoccupations which led to the proposal of the act. And the proposal, what we do is that we are proposing to harmonize the requirements for safety, resilience, and also environmental sustainability all over Europe, and create a single market for space. So this is the objective.
So a single market, but with goals in terms of security and resilience and safety. Why is such an act necessary? I mean, companies are themselves concerned to have satellites that are robust, resilient. Why is such a space act necessary?
Well, because we see first two things. One is that until 20 years ago, satellite operations were really an area in which only state actors were active. So there clearly it were the national space agencies that were in charge. Launching satellites, because there was no business case. But 20 years ago, this all changed, and with the arrival of new actors, space became an area in which also businesses are now very active. And of course, we know this because the fact that we have new companies in dramatically decreased the prices of how much does it cost to launch to space. So of course there is an activity, and the newcomers are coming, and this is great. However, the risk is that with having more satellites and more objects in space, again, coming back, the risk of collisions is very high. And then what is prediction is that there will be in the next decade over 50,000 new satellites launched. So this really adds up to the potential risk that we see. And now you might say, well, that's fine. We have some rules already in place. Why do we need the Space Act for that? Well, because these rules, of course, these rules are existing, and we have the whole UN framework that was created, and that is there since the 70s, which we have the Outer Space Treaty. But there are no technical requirements that are obligatory on the international level. There are, of course, requirements for the member states, which stem from these UN treaties, and we respect that. But when we come to the technical obligations, these are on the voluntary, non-binding basis. So it is important to have a first step into this area and try to find common agreement on what would be required if we launch. Because, of course, the EU member states, they reflected upon these challenges, and that is why they have different EU space laws in various countries in Europe. However, these space laws vary in their way how they address these different challenges. Hence, we feel that there is a need to agree upon a common baseline, a common rule book on what do we require in terms of safety, in terms of resilience, and in terms of environmental sustainability from space operators.
Okay, so yeah, some countries have already got some legislation in place. Presumably, part of the work is to look at the compatibility with national administrations, and or for the member states to react where they have legislation in place, and presumably this will avoid duplication.
Yeah, I mean, we are not replacing the national authorities. This is they will still keep, of course. We are not touching on the prerogative of national administrations. They have their, of course, they have their obligations that they need to do for authorization, registration, etc., and liability. All that stays. I mean, we are not taking that away in any case. What we are proposing is to have a common understanding of what these technical requirements are all over Europe. So these requirements are same in one country in the EU and the same in the other country of the EU. And on the top of that, the requirements that would then these are parts of the authorizations that need to be issued by the member states. What the whole purpose of this is that once the requirements for safety, resilience, and environmental sustainability are authorized in one country, it would mean that they would be also valid in the other EU member states.
Okay. The ERSC represents the commercial sector, companies dealing with Earth observation services, including data provision and data services. What is the sort of so the Space Act is dealing with commercial satellites and those owned by the public sector, I presume.
Yes.
So there's quite a lot of crossover in some areas between the public and the private in terms of data, in terms even of operating satellites. This could potentially make some of these issues hard to control. Is that how's that being addressed within the Space Act?
Can you please rephrase? What do you mean by control?
Well, I guess very simple way of expressing it is do the obligations apply? Presumably, the obligations apply to publicly owned satellites as well as commercial ones. And is there any difference in the obligations for commercial and public satellites?
Well, the difference, okay, you're right. The difference is that there's one important thing to say is that this act does not apply to any military or defense related areas. So these satellites are exempted from the scope. But otherwise, both commercial and the governmental satellites would, of course, need to comply with the same set of requirements. This is the whole point, because in space there is no difference. I mean, we need to provide equal treatment. I mean, If it is enough to have one satellite that has not fulfilled a certain safety requirement, that can then accidentally go out of orbit or cause a collision with another one. Hence, all this is in the scope, except, as I said, the military and defense. This we don't touch.
And I mean, we have this often have this concept of dual use. So satellites are both civil and commercial and military, fulfilling part of the military goals. How will that boundary be defined? Is that due to the customer or the nature of the satellite? Will there be?
Yeah, it is the member states, because they are the ones that, because of course military use or defense related use is in the realm of a governmental use. Hence, it is the government that will define which satellite, when it's used, is used for that, for the mission of the satellite is dual use. In that case, of course, this is out of the scope of the regulation.
So it will be up to the member states to
Yes.
define whether the satellite has a military objective.
Yes.
In part or in whole. Okay. Who, in your view, who is likely to be affected? The Earth members are mainly value-added companies, but we have a number who are satellite operators and a number who are data distributors. The primary legislation is targeted on those operating or selling data, I believe, and not on the value added. But what are the implications for each of these categories of company? Company.
So your question is, what is the impact on the primary data operators?
Yeah, so the three classes: the EO service providers, data providers, and satellite operators.
Okay, so the satellite operators, they would need to comply with the regular authorization process, as I said, in their own member states. So if they want to launch a satellite, they need to go to their national authority that provides the authorization. Again, as said, what is changing is that once this law is hopefully adopted, we will have a single set of these requirements for safety, resilience, and environmental sustainability in Europe. Therefore, if they would need to apply for a authorization in another country, for example, in case it is necessary to operate the satellites from another country, that part of that authorization would be already accepted. So that's their situation. Then you asked about the primary data providers. The primary data providers, the data are targeted only the data that comes for the first time in the EU single market. Why is it so? Because the scope of this legislation is to talk about space services and about space-based data. So once these space services and space-based data come to the EU single market, especially for the space-based data, what we need to prove is that the infrastructure, the satellites that generated that data complies with the requirements of the legislation. And for that, there is a whole system of an e-certificate that will be developed. So this is the point.
Okay, and so we talk about the primary providers of space-based data. Those are the satellite owners and operators, and not resellers.
Well, I mean, we talk about we talk about for the first time that this data arrived to the EU single market. So if before this data is I don't know, manipulated or between other actors which are outside of the union, this we don't target. But the moment they come in, so yes, we also target the resellers, because imagine in the other situation, if we would not target them, there would be a loophole. It would be very easy just for a certain country data provider to have a data broker, sell the data there. and then say, okay, that's not the first time that this is provided, hence we don't have to comply with the requirements. So again, it's the first time that the data accesses or comes to the EU single market.
Okay. I think there's quite a lot there to unwrap, but maybe I can come back to the sort of the basis of. I mean, I think the idea is largely controlling of space debris, deorbiting of satellites, light pollution, which is
As well, yes.
very much needs to be addressed, safety. But there are provisions in the Act for cybersecurity as well. And maybe I'm missing something, but I mean, cybersecurity is controlled by quite a number of other legislative packages, different parts of legislation. Why is there what is the specificities, sorry, of cybersecurity for satellites?
Yes, so indeed, you're right. There is currently in Europe the so-called NIS2 legislation, which is about cybersecurity. And of course, in creation of this legislative proposal, we had a number of exchanges with our colleagues in the European Commission, also with the stakeholder community. How will this work, and why do we do this? I mean, what is so special, as you're asking about space? Well, what is so special about space is that in our analysis, we feel that there is a need to create a so-called lex specialis for the space activities, because the NIS2 is going far, but not far enough. So it covers a number of aspects. I wouldn't go into detail right now because this is one of those topics that is currently discussed in the Council with the EU member states. So I wouldn't like to elaborate, but what I would like to say is, as we see it, definitely this is not, the proposal that we have is not going against existing legislation. It is complementary to the existing cybersecurity legislation that there is.
Okay. So part that for the moment then. I mean, space assets are becoming much more critical in terms of the geostrategic positioning at the moment, and the evolution of, and of course this is changing very fast. So I think, how much will satellites be considered as critical infrastructure and subject to these controls? And are there exemptions in terms of critical infrastructure? And I've also seen the term essential infrastructure. So what's the difference there?
Well, as said, I mean, the satellites themselves can be considered a critical infrastructure in our terms if it's linked to a use that is security related. So in that case, of course, we are not defining what is a critical infrastructure and what not in this act, so we are not going in those details. But I agree with you that satellites and this whole space infrastructure is indispensable and can be considered as a critical infrastructure because so many services are dependent on it. I mean, we cannot imagine what would happen if we would not have all the services that we have based on space infrastructure. So clearly, this, in my personal view, this is definitely an area where I would say it is it's critical to our economy. I mean, there are studies that say that there are, for example, for navigation services, this is more than 10% of the economy, of the European economy, that is dependent on it. So in general, I can say that in my view, yes, indeed, this is a critical infrastructure.
I'm surprised it's not more. Same with Earth observation. I mean, the contribution to the economy, you know, we've been doing some work in that respect with ESA, and hopefully there'll be a lot more work because the range of applications of EO data is so broad, and the fits into society is very much not fully understood, or people are certainly not aware.
Yes, because it's taken for granted, no, isn't it? Especially for Earth observation data, this is definitely a little bit taken as for granted. So often the users, they don't see what is behind, that you have to have the whole infrastructure behind, the whole setup. The data just don't come out of nowhere. I mean,
No, I was talking to somebody in NOAA a few days ago, and the old canard came up, about, well, the message that's coming down is, well, we don't need to build more meteorological satellites because we get it all off the television. It's an old story, but still seems to be very relevant and very strongly part of the debate in the US at the moment.
Yeah, well, probably the more competent people of NOAA has already left. So
yeah, I think most of the people in NOAA understand. It's it's those who are setting their budgets that are less informed or understand less the whole setup. In terms of international, this applies to any company, any company, trying to do business in the union. So it applies to companies elsewhere in the world. What discussions have you had with other countries in relation to this act, and well, something which even goes broader as a global basis?
But maybe before I dive into the third countries, just explain once again what are we targeting here. So there are three areas or three types of authorizations or registrations that we are talking about. And registration is not meant in the UN type of registration. It is meant in a way of like subscribing to a repository of data, which is called URSO in the Act. So we are talking about the so-called union operators. So these are companies that are in any EU member states, which need to get their authorizations in their own member states. And as we said, part of this authorization is related to these three aspects, and that's what we need to harmonize. Then there is another category, which are the union-owned assets. So meaning our Galileo satellites, Copernicus satellites, and for those, the system or the governance which we would like to put in place is through the EU Space Program Agency in Prague. So they would be that would be the main point where the authorization would need to be get. And then we have the third category, because this act applies to both EU and non-EU operators. They are the third country operators. And these third country operators, we of course we cannot check. We cannot. The EU of course cannot be in charge of their authorizations. This is done by their own countries. This we don't touch. But what we would like to know is whether the authorizations that they were given in order to operate in space are compliant with the requirements which are in our act. So this is what we are doing. And this exact point, whether they are compliant, is that what we need to check and then decide upon whether it is compliant or not. So this is how we deal with the third country operators. Then, of course, with some of the countries that have a similarly developed regime, and here, for example, I have in mind the US, because they, of course, this is our biggest transatlantic partner, and they have regulations that are close, similar to what we are trying to do. There we see a possibility that in the future we would have an equivalent scheme. We would have an agreement that our requirements are accepted in the US and vice versa, so there will be an equivalence. Or there is also a possibility of having an international agreement with particular countries. For those operators that would not fit into any of these categories, they would need to prove through a system of applying for such a registration for delivering their services in the EU. They would need to prove that their data, whatever they're providing, is again compliant with the requirements of the regulation.
So companies selling data from a non-European satellite would need to show that they comply with the same safety and resilience factors which are defined in the legislation.
Yes, but this is again, this is nothing let's say, worrying, because if you take, for example, I take the example of the US, which is, of course, one of the biggest countries that is launching satellites. There we know, and we have, of course, looked into the requirements of the FCC, of the FAA, what they need to do, and we see that, I mean, there is a majority of things that they are required to do, we are also requiring. So it's not like it's completely unknown. There wouldn't be, of course, this is then subject to negotiations and to see exactly in details. But what the purpose is not to restrict the access. The purpose is, again, the big purpose is to ensure that there is a long-term sustainability of space activities. And this, I think, I can honestly say that we can share these objectives with the US administration, because it's also in their interest to make sure that there is sustainability of space activities. Again, it takes just one satellite to go off course and create a collision.
Yeah.
And that can go wrong. So just,
and many constellations that could cause problems. But I guess the question of transparency with the US, of course, also comes up at the moment. But other countries may not be so transparent, may not be so willing to confirm compliance. So they would then not be able to operate in the European market.
That's the consequence.
Yeah. Okay. Just to be clear on that.
It's very clear. I mean, well, the good news is, again, that this law will be, or what we are proposing is it will be applied to new satellites that are going to be launched after 2030. So we have to put things into perspective. It is not tomorrow that we are going to restrict anything. It is, first of all, has to be negotiated in the ordinary legislative procedure with the Council and the Parliament. Then once we have an agreed text, then that has to be adopted. And after that, we can see, we have some time, hopefully, to prepare for the implementation of the act. So what we had in mind was not to create a regulation that will be for tomorrow or in 2 years. This regulation, I think, in realistic terms, will kick in about 7 to 10 years. That's where the applicability will come. But we have to already see the future in a way that we have to prepare. As I was saying, if we expect that the number of satellites will dramatically increase and there will be a number of launches, we need to prepare for those risks that are coming. So this is all about preventing potential risks that are coming in.
So 7 to 10 years sounds like a long time for.
Not really. I mean, not really. I mean,
in space terms, it isn't. But
no, because you can. I mean, the fact that we are already starting the discussion about the space act, that also brings the attention of the companies and also for example, members of your association, that they would know, okay, we need to take care of this and this aspect. Let's have a look what the Commission is proposing, where we are going, because it is not we are not proposing to their detriment. The whole objective, again, of this is to ensure the long-term sustainability of space. So it makes sense to make sure that whatever we launch is compliant with the requirements, because there is a good reason for that.
Yeah.
And just to say, I mean, there are also many countries that are updating their safety regulations, like India, for example. They're also doing that. I mean, it's not that the Commission is trying to go forward with something which is new. I mean, there's a lot of activity on the UN level, but again, on the UN level, there are no technically binding requirements. So we try to make it binding so that we really make sure that's there, and hopefully the rest of the world will also follow. So we try to set the trend.
Okay, you already answered my next question, which was around what happens next, what's the process and the timing. So as I understand it, you're talking about coming into effect around 2030 and then being biting, if I use that term, maybe in around 2035.
Well, okay, let's rewind. So there is a process, the legislative process, which we hope that can be, I mean, it usually takes, we tabled the proposal in June, it usually takes about 1.5 to 2 years in order to make sure that we finalize the whole European ordinary legislative process. This involves a number of meetings with all the stakeholders, explaining and going into the details with the member states, with the European Parliament, and trying to then find a compromise through the trialogue process to arrive to having a proposal. Now, of course, I don't have a crystal ball, so I cannot tell you when exactly this will be. My assumption would be that in the, let's say, classical process of 1.5 years, 2 years, we are there. So that's when the proposal would be adopted. Then we would have some time to prepare, because this would be, let's say, in 2020, end of 2026, 27. So then we would have some time to prepare and to make sure that our companies in Europe understand what their requirements are. So we will have a number of guidelines, a number of information portals, ways of supporting them to make sure that they understand what we are proposing. And then with that, as of 2030, this is the deadline or proposal in the Act. For those satellites that are new, not those that are on the process of manufacturing currently or in 2030, that are really, really new, those one would need to be compliant. So this is the process.
Okay.
That's why I'm saying that it will kick in a little bit later, because until these satellites are launched, we are in that timeline.
Okay. I mentioned earlier that ERSC has a working group which is working to understand and develop understanding of the Act and to see if there are any concerns. I mentioned Michelle Hammers. I guess she's Michelle.
Here.
You want to just say a few words about the working group and the plan paper?
Yeah, sure. I can jump in quickly. I mean, I think we're gonna touch on so in the group we have about 25 companies right now, and it's been quite constructive so far. So we've already had 2 meetings to discuss different aspects, concerns, things that are unclear, also with some experts in the legal domain. And we're working on our first position paper now, which will just touch on some of the positive aspects and some of the concerns or some of the things that are unclear. And we sort of split it by the different types of companies that ERSC represents, and give some suggestions and ideas for some of the aspects going forward. So we're really happy to have you here and excited to continue engaging with you and with the co-legislators throughout the process. So yeah, that was just the elevator pitch for the task force. And if there are any other members of ERSC that don't know about it or want to join, you can email me, and we'd be happy to have you on board.
Great, thanks, Michelle. Let's turn to 1 or 2 questions now. I think Emmanuel made the first comment, but Wolfhard has the first question. So can I turn to Wolfhard?
I tried to unmute myself, and apparently I'm successful with this. Okay, I tried to summarize. There's actually 3 questions that I was asking, and I'm trying to summarize these. They're concerning the harmonization between national regulations, and with this I'm referring specifically not to an overall Space Act, but to individual regulations, like for instance the data security laws that are in place in Germany, that are in place looking at ESA countries, Canada. Those are harmonized, but then there's other data security laws by other countries. So we're looking at a kind of a puzzle between different regulations touching individual aspects of space security, space data security, maybe cybersecurity. Now, my question is, will all these individual isolated regulations that are maybe harmonized bilaterally between 1 or 2 countries or 3 countries, will those also be harmonized and come under an umbrella with the EU Space Act? Because this would make it a lot easier to deal with companies from other countries, or deal with other governments, like for instance between Canadian, Italian, German, Spanish, where there's potentially joint missions. So will this be an umbrella? And my other question actually goes into, let's say the EU Commission is putting a lot of work into the Space Act. At the same time, the US Trump administration is going into big deregulation. including space. So could the EU attempt to harmonize and to create a template of a Space Act be an isolated initiative, while the US, especially commercial satellite operators, are flying freely? So these are my two questions.
Okay, thanks a lot. So if I understand correctly, so you are asking whether the data, whether we are providing some kind of a harmonized umbrella for the data security laws. No.
As one example, there's other national regulations as well, and they could divert between different countries, which makes it sometimes very complicated to, for instance, operate a mission under or with participants from different countries. This makes it currently very complicated. Okay,
I mean, I understand your question, but again, what is our take on data is that what we need to see is the security of the satellite. So we are, again, from the data perspective, what we need is to make sure that the data that is created by the infrastructure, that data comes from an infrastructure that is secure, resilient. We don't discuss the data itself. That is not the objective. Again, it is a bit of a complicated concept, or looks complicated, but we, in order to make sure that we don't disadvantage our own satellite manufacturers, because if we would do these recommendations just on the level of, okay, we have to create this and this for your satellites, this would put our own manufacturers in a disadvantageous situation vis-a-vis anybody else. Hence, our approach is single market approach, meaning that we target data that comes in, and for that data, those providers need to have a certificate that says, okay, the satellite that provides this data is compliant. This is all. Now, with your second question, that was with regard to the US. What I understood, you said that they don't have such the commercial satellites, they don't have such regulations, or you don't see that. I would not agree with this, because the FCC and FAA, they really have quite stringent regulation in order regulating what needs to be sent in space. So I don't know what exactly you had in mind.
I do agree. Yes, they have very strict regulations, but at the same time, what we keep hearing from the Trump administration, especially through Canada, for instance, through Canadian sources, is that the administration is trying to deregulate the space market again, including also space security. Will this impact? If this really happens, will this impact the effectiveness of the European Act?
Well, I mean, you might be referring, I remember very well that over my summer holidays in August, I read one of the executive orders of the President Trump on the beach. And that executive order actually is called Competitiveness of the US Industry in Space. When I read it, my understanding is that this concerns mostly environmental provisions that are in the US, and this has to do, again, my interpretation, with the sites, or with the launch sites. If these launch sites are, I know that there was an issue of a launch site which was close to a natural reserve. So I think the target of that was not the safety, because the safety really, I mean, SpaceX, and this is one of the top of the class in terms of safety. It was more on the environmental requirements that they are for well, they call it satellite competitive, space competitiveness, but I think it's more related to that.
Okay, thank you.
Yeah.
Okay. Thanks, Wolfhard. So Sally Stevens asked you a question around this, the role of ESA, the way ESA fits. Sally, do you want to?
Yes. Hi. Thanks,
your
Jeff.
concern?
Thank you. It's just to say, so I'm from Space for Climate, and we are a UK membership organisation for the satellite Earth observation climate community. So we have obviously a slightly complex relationship in terms of European projects, but we are a very busy collaborator with lots of organisations across Europe. on satellites, because obviously we are a member nation of the European Space Agency. So I'd be interested to hear an insight on whether ESA would be treated as an entity in itself, the same as any other member country, and whether that would therefore cover the UK Earth observation community as well.
Mm-hmm. So with regard to ESA, ESA is, well, starting the European Space Agency is a very trusted partner to the European Commission in terms of their technical excellence in everything what they do. We respect them very much. They are an international organization, hence they belong to the group of international organizations to which this the scope of this act is applicable. Now we have in the proposal a particular article which deals with relations with European Space Agency, first of all recognizing their special role, and secondly calling for a international agreement with the European Space Agency that would exactly define how the relation between the Union and the ESA would be in terms of applicability of these provisions. So that's how we see it. So as a very special partner, a separate article in the proposal, and then concretely what and how this is then defined in the international agreement.
That's excellent. Thank you very much. It's really informative, Susanna, and you've been very helpful. Is there a contact point that I could follow up on that with? Would it be through you?
Yeah, you can contact me. I mean, depends on what exactly you would like to ask, but yeah, okay. So I mean, you have my contacts, and then a little bit of promotion. I mean, for all the participants, we are also running a stakeholder consultation on the proposal for the act, and I will share with Jeff the link, and then I can send it to all of you. It's in all EU languages, so you can read the proposal now. It exists not only in English but in all the other languages, and it is open. The latest date which I have here is 20th of November. So we would be very grateful if you can provide any of your ideas or comments also through this channel. So that's an open channel, and we will take that into account in the next negotiation rounds that we have, which is very important for us. Just to say,
that would include responses from UK organisations.
Anybody can do that. I mean, this is open to everyone.
Fabulous, thank you.
So that's good. And just
even outside, you can comment, Sally. It's okay.
It's open to anybody. U.S. companies can come through this as well. I mean, we appreciate their inputs as well. There is a lot that they have to say, and this is the way. Because just to say, of course, this act was prepared in consultation with the stakeholders, but the final, let's say, the final cooking was done internally in the Commission with our own services here, and so the result was something that nobody's seen before. This is a proposal from the European Commission, so that's why we have, according to the better regulation, this possibility of having a consultation which is now ongoing. And please be so kind, add it.
And after the EOcafe in the next couple of days, you'll get a mail with any relevant information. Will go out to all those who registered for the event. We've had about, I guess, 140 people online. We had over 300 registered, and we go on registrations because a lot of people come and look at the recordings afterwards. So there's a lot of people. So anybody who registered will get the information. So anything complimentary, Susanna, if you provide.
Yeah, and I see that somebody already shared some links in the chat. Yeah, Michelle. Okay, thank you.
Yeah,
it's probably that I haven't seen it, but yes.
I hadn't got there.
Yes, yes, it's very good. Thank you, Michelle. Yes, that's exactly.
You're welcome.
So, further question on cyber, Jacques. Jacques, can you where are you from? Can you just introduce yourself as you join?
Hello, Jacques Kruse-Wandau is my name. I'm with TÜV Nord Group in Germany, and we are running cybersecurity evaluations of software and hardware and components, also for satellite systems. My question was, or would be, why the Cyber Resilience Act was not referred to in the EU Space Act draft version or proposal now. As we background is that we have a 10 years negotiation between the member states behind us, and it results in the Cyber Resilience Act addressing products with digital elements. And such a harmonization between 27 member states is a huge step, right? Which would give us the benefit of making use of it also in the segment of space, ground segment and space segment, and in space. And that's why I was wondering why this was not referenced.
Well, I would need to double check with the colleagues on this because honestly, I'm not sure. I would think that it is because we do not address manufacturers, only the operators, but I would need to double check on that. I mean, that's to reply to your question on Cyber Resilience Act. Okay,
Okay, thank you.
It can be a follow-up. Thanks.
Okay, thanks, Jacques. Emmanuel, good to see you here. You've got a couple of questions, I think 3 questions in the chat. Do you want to put one of those?
Yeah. And then the annoying question are arriving. Thanks, Jeff. Very interesting, Susanna. Yeah, 3 very different ones. You were mentioning that NIS2 is complementary to EU Space Act. I was wondering, is it rather overlapping than complementary? There are real topics regarding cybersecurity which are questionable, but it was already touched by my colleague before. The second point, which is I think the most important one, EUSPA. So we noticed a couple of years ago that EUSPA got Copernicus downstream services support. To be honest, they didn't get neither the manpower nor the budget to manage this. So my question is there any plan to get enough budget and manpower for EUSPA in order to support the implementation of the EU Space Act?
Okay, you had, Emmanuel, only 2 questions, or there is a third one?
No, I gave him one, so.
Okay.
The third one, but
the second one.
The third one is.
I thought you said 3, so I wasn't sure.
No, the third one is a remark, but you know that's my toy. I'm deeply involved in data sharing initiative, and I was referring to the EU Space Act addressing mostly for me the upstream space single market. And any idea about the downstream space single market and any link with the forthcoming European Data Union strategy? But Susanna, we will take this one offline, I think, because we need half a day.
Okay, thanks for that. So maybe coming back to your question on this, as I said, it's complementary. I wouldn't like to go into this discussion on cybersecurity because you may understand it's a very sensitive topic for our member states as well, and we need to discuss this with them first. What I said is that we are convinced that this is complementary. There are good reasons for why space is important and needs to have a special legislation on its own, but there is no duplication because, for example, the reporting would be the same through the NIS authorities. So, but I don't want to go into the details. This is subject to ongoing discussions. If you allow me, maybe in a month or 2 months' time, we can revisit this. This is, as I said, a sensitive issue. When it comes to EUSPA, you are very right. And thanks for remembering this. So this is the EU Space Program Agency in Prague. Indeed, a couple of years ago, exactly in 2021, they got additional tasks for this Copernicus downstream. And indeed, there might have been some issues with the resources. So in order to avoid this situation, we have proposed the legislative act is also accompanied by a proposal for finances and resources. So we propose to boost the number of resources for EUSPA, definitely, because we are also empowering them and giving them new tasks, and there needs to be, of course, personnel and people who can deliver on these new tasks. The discussion and the decision on how many people, how the budget will be increased, this is out of the hands of the Commission. This is again the European Council and the European Parliament that would need to decide on this. But indeed, of course, we realize and we understand that there is no way to give new tasks without appropriate resources, be it financial or human resources. So this is what we have.
Great news. Thanks.
Thanks, Emmanuel. So we've got 5 minutes left. I'd like to take perhaps 2 more questions. The first one, Bryn Lashley from GHG SAT, who are very much concerned. Bryn?
Hello, and thanks for the great and informative discussion. So just a bit of context, GHG SAT is a Canadian operator and a Canadian data service provider within the EU, and we are a Copernicus contributing mission, as well as a ESA third-party mission. So my question had to do with the exemptions provided for satellites used for defense and security purposes. You mentioned that that is specifically defined by the member states, but how is that then defined for third-party country operators?
Mm-hmm. Well, but can you rephrase? So you are so your company is providing military defense related services to EU member states, right?
Not presently, but as was mentioned during the discussion, the dual use of space is becoming a lot more applicable, and with the kind of ramp up of defense in Canada as well, new use cases are being explored. And so it's possible that that could happen in the future, but currently it's not provided to European entities.
Okay. Well, you're talking about then about third country governmental satellites. So, for example, if the government of Canada is using this, just to, I don't.
Correct. Like, let's say it's a situation where you know, a commercial satellite operator within a third-party country is providing military applications to that third-party country. Would that then be viewed as an exemption?
And presumably it could be claimed that...
Can you just let me consult this for a second, the law itself?
Sorry, I didn't mean to have such a tricky one.
We might have a derogation we have an article on third country public entities, which is Article 20. So yes, so we would need to first assess whether the third country public entity is a governmental entity or not. Yes, so yeah, there will need to be a process of assessment by EUSPA, so by the agency, and based on that assessment, the Commission would need to take a decision if I read this correctly. But I can come back to you. But I see that there is an article on this, but there are sensitivities around this, so it's not an easy question. It's a bit complex. Okay, yeah. But notes taken, and we can come back to that.
I appreciate that. Thank you.
Thanks.
But I guess it could be used by a third country as an argument to say, well, we're exempt because applications from the satellite are used by our military, and therefore we define it as military, and therefore claim an exemption.
Yeah, but then in that case, you can say that any satellite is dual use, and then we exempt everything, and the whole purpose of the law is lost. No, it has to be related to the mission, because it's more on a case-by-case basis. So we cannot say that the exemption cannot be for any data that is or service that is provided by that satellite. It has to be assessed on a case-by-case basis by saying that, okay, because you're going to have satellites that are being used for civil purpose, and then for a certain period of time are used for dual purpose. So that's one way. Or a part of the satellite is used for dual, and the other part there's another payload that is used for civil. So there, it's really case by case basis. It's difficult to have a one.
I guess my point is, you're defining some of those boundaries may be hard, maybe difficult.
Yeah. Yeah. This is, I mean, we are going into new territory, but as I said, probably the best way to put it is case by case.
Yeah, okay. So I wanted then just to take one more question from Stefano Natali, which I'm not quite sure if it's a question or observation, concerning the onboard processing and the refinement of definition of data, I guess. Stefano?
Yeah. Hi, everyone. Can you hear me?
Yeah.
Okay. No, I went through the EU Space Act, and I think that it's the objective is clear, to regulate more what is flying, more than what is generated by what is flying.
Mm-hmm.
But it's going to change. If you say that this is going to have its applicability in 10 years from now, there will be a total mix of flying and generating data and generating information, and what is flying will be anyway part of the production of the data, and at the end of the security of the infrastructure itself. So there will be a lot of processing there, and so it will be also security wise part. It will be also needed to have more protection. So everything that is related to the cyber part that was already mentioned, everything that is related to the AI part through the EI Act will be related anyway. So we can start defining this, let's say, EU Space Act, focusing and targeting mainly to the upstream and to the security of the flying part. But it will be needed anyway to have a consideration and integration with all that is the data process. The data processing is just when we talk about downstream is everything is Earth observation. That is where we are focused on, but it's also navigation. It is telecommunication, and taking this part totally aside for me at this point is starting with let's say something that is incomplete. But that's only my note, not a question, more a note.
An observation. Okay.
Yeah.
Any reactions, Susanna?
Well, I mean, we are in as it is proposed, our scope is the full value chain. It's not just the satellite themselves, but that's what I was trying to explain, is that we are targeting the end product in order to get to the requirements of the infrastructure, how this is done. So this is what I can say.
Okay. So thank you very much, Susanna. I think it's been a really interesting discussion, and we've touched on a number of points. I'm sure Michelle has been taking a lot of notes from what's been said. I'll wrap up at that point. Is there any last comment you want to make? Obviously, invite people to react, to comment, and give their views.
Maybe, yeah. The one thing is to give their views, but also don't be discouraged by how complex maybe this proposal looks. It's in its way, it's relatively simple. We try to make sure, as I said, to ensure the long-term sustainability of space through a simple approach. Our simple approach is to make sure that requirements are all over the same in Europe. And why this is important is that for European companies, we would have the legal certainty of having the same technical requirements all over in all countries. And we hear from companies that this is very important for them, especially those that have businesses in various countries where the legislation differ. So I would like to invite you to see it from this perspective. And as I said, there is time to prepare. So hopefully you will have time to prepare. And more importantly, I forgot to say one thing, proportionality. We also have provisions that for smaller companies and SMEs, there is a light regime created, so we don't apply exactly the same rules. So there's a bit of a light regime created for them. So this is not so complex for them, but we can discuss that separately. Please have a look at the proposal, and thank you very much for inviting me. It was a pleasure for me. I think it went well. So I'm happy to be here, and I hope that this was useful for the community.
Yeah, thank you very much. If you can stay around, we normally just have a sort of an open microphone at the end. We turn the recording off and we say anybody can say anything they want. So if you could stay around, that will allow any more observations to be made. But otherwise, thank you again for participating. And we look forward to further engagement in the future over the Act and as it develops. So the next EOcafe will be in I think it's 3 weeks' time, the 16th of October. It will be our 100th EOcafe. So we're going back to Mauro, who was with us in the very first EOcafe, and we'll talk a little bit about how the world has changed in the post-COVID era. I think we'll probably go back before that as well. So join us then. It should be interesting to just simply to reflect on how the world has been changing, particularly relating to Copernicus, but in many other ways as well. So hopefully a lot of you will join us then, as well as others. As I just said, we now sort of shut down, end the EOcafe, but microphones are open. Anybody can just join in and say something if they wish. And thank you all for being with us. Thanks.